All right, welcome everyone. Thank you so much. Pretty timely. It's 2:05 and we have our quorum for the commissioners. So let's go around quickly and introduce who each of you are. Maybe I will introduce our fantastic staff. We have our Executive Director, Matt Barraza, Soraya Gatmeyer. I think it's Josh, right? Buhay? Yep. And let's see, we've got Adam Troop, and we have Leslie Howitt, Deborah Nelson. I think that's all the staff that's on the call right now. And then just so everyone can hear the commissioners and know who you are, thanks again. We have an amazing group of commissioners willing to serve. They're paid zero for this extra opportunity, and it's a fantastic group. So I'm Maureen Kamalu, not an attorney or a judge, but kind of a normal person and chairing this fine group. And then John, go ahead and share who you are.
I'm John Quarm. Anything in particular you would want us to share about ourselves?
Oh, maybe which spot you fill from the disciplines required by the law is always interesting. And okay. I think you can be reminded of what that is.
Yes, I know I was nominated for the position by the Minority Bar Association.
That's it.
But off the top of my head, I cannot remember the title that they gave me, but that's who I am.
Yeah, John Quarm. We're so happy he's part of this group. Thank you, John.
Thank you.
Okay, Margaret.
Margaret Lindsay, Utah County Public Defender Association, and I'm Child Welfare Representative.
Yes, thank you. Kendall.
Kendall Thomas, Twilla County Councilman, and a pretty new member of this commission, so glad to associate with everyone.
Yes, Kendall, we're so happy to have you.
Thanks.
You're a normal person too, like me. Okay, let's go to Wally.
Wally Bogdan, I'm a defense attorney, private practice.
Thank you. Aaron.
Aaron McKnight. I am one of the representatives from the Utah League of Cities and Towns. I work for Orem City.
Yeah, so glad to have you too. You're a little bit newer.
Old buddy of John Quarm's. We went to law school together and suffered through post together.
Oh my gosh.
Good to see you.
You too.
Yeah, I saw him get a big smile. I figured there was a connection. That's pretty fun. It starts to be a small world, I've realized, especially in the legal community. Judge Zimmerman.
Yes, Michael Zimmerman. I'm just a commission member.
Well, yeah, and a former Utah Supreme Court. Were you the Chief Justice?
That's true. Yeah, I was. Yep, that's true.
You don't fall in the normal person category. Sorry.
No. Okay.
Pam.
Hi, everybody. I'm Pam. I'm a youth defense attorney in delinquency on the delinquency side.
Yes, thank you. Rich.
I'm Rich Morrow. I'm the executive director of the Salt Lake Legal Defender Association, and I represent the full-time public defender agencies.
Yes. Okay, I think we covered everyone. Matt, does it look like we got everyone? Anyone I missed?
Commissioner Russ.
Oh yeah, Commissioner Russ.
That's all right. And I guess based on today's introductions, I'm a normal person too. So that's not always, I feel like I'm in that category. So that's good. Tom Ross, the executive director of the Commission on Criminal and Juvenile Justice, which is a governor appointed position. And based on my role here, I'm also on the commission.
Yes, we're so happy that you said yes to that, Governor. Thank you. Okay, and we do have a special guest. We'll get to you, Daniel, in a little bit. First up, though, we have the approval of minutes. I did read those before this meeting, went through them. They look very accurate to me. So I'm happy to move approval. But if there's anything someone saw, bring it up. Or I'll take a second.
Second.
Okay, I think that first one was Kendall. Is that true?
Yep.
Okay, Kendall. And then all in favor, you can say aye or just raise your hand. Aye.
Aye.
Okay, we got you. Looks like it's unanimous. Okay, thank you so much. So with that, whoever is going to introduce Dr. Daniel Lancaster, he has a presentation to us today, which is the Weber County Regional Forensic Social Worker presentation. And this will be really nice for him to present to us today.
That he also has with him there the director of the Weber County Public Defender Group, Jim Ritalik. And for those who don't know, last session, Weber County was able to obtain funding for a project to provide forensic social worker services to other counties within the region. It's a 2-year project. So they're coming up on their 1-year anniversary of that being created. And if anybody who has ever worked with a forensic social worker as part of their practice, especially in a public defender office, knows what a vital resource that is and how that can really change the dynamic of a case, especially when we're talking about serious allegations. And so with that project coming on the 1-year anniversary, I invited Daniel and Jim to come and talk to us about how it's going, and the work that they're doing. And I hope that their work can continue, and it's something that I hope can be replicated in other parts of the state.
Yes,
So I'll
wonderful.
turn it
Great.
over to.
And Jim, I don't think I've ever met you. That's what I've heard a lot about you. It's nice to see who you are.
Commissioner. Jim Ritalik, I'm the director of the Weber Public Defender Group. We are the first full-time county-based public defender office in the state. Just want to introduce Daniel, my colleague and a good friend. We have, when I took this position, I visited LDA and then Utah County Public Defenders to see. I didn't want to reinvent the wheel, and I found that their forensic social work divisions were some of the most important components that they had, and so that was one of my goals. I believed we had divine intervention. I would run into somebody and they said, "Oh, have you heard about the opioid settlement fund?" I was able to chase that down, and that is how we got Daniel. We were able to get the Weber County to agree to use opioid settlement funds for Daniel's salary and benefits. And so since we had that, we have been building this office. Daniel and I put together a presentation to the Utah State Legislature last year, as Matt mentioned, and we're successful in obtaining funding for the Regional Forensic Social Work Office, which provides forensic social work services to Davis, Morgan, Weber, and Box Elder counties public defender groups. And because they're all part of our public defense, because Daniel and our team is part of our office, they all have the protections of attorney-client privilege, which has been fantastic. We've been able to solve many cases that we would not ordinarily have been able to solve without the forensic social workers. They're the critical heartbeat of our organization. And having said that, I'm going to turn the time over to Daniel.
Thanks, Jim. Awesome. I, of course, have a PowerPoint because that's how this whole world operates, right? I'm okay to just share my screen. Should work, maybe. Let's see here. Just waiting to. Okay. Is everybody seeing the presentation formal, or are you seeing the slide deck side?
We just see the formal.
Okay, great. Perfect. Yeah, well, so to take it away, here is an agenda with way too many slides. I'm going to burn through as many as I can. I'm trying to keep it to 30 minutes in respect for your time. There's just a lot of exciting things to sort of talk about. I'm quite passionate about this. And if I could note, just, I came to this work, I've been in the field of behavioral health since about 2007, and then a master's level clinician from 2011 on. And I I guess what I want everybody to know before I keep yammering is that I've been in behavioral health long enough that I have an almost militant commitment to evidence-based practice, and I have no patience for fluffy nonsense. And I spent some time at Huntsman Cancer Hospital doing oncology social work, and that's where I really picked up what evidence-based practice should look like. It's probably easily the most rigorous medical field in terms of proving efficacy of treatments and why very specific treatments need to go to very specific disorders. And I've carried that with me now into criminal justice related social work. I have on here a few items at the very bottom. Slide 21 is questions. I'm also a fan, though, of just taking questions as we go. If something comes up, if you've got a clarifying question or if you just want more information, please speak up, shoot up a hand. I'm all too happy to accommodate as we go.
I will help watch the chat as well. Bring those
Oh.
up Daniel, when people put something there.
Perfect. Thank you, Commissioner. So the first thing, though, before I get too far into the update, is I've got to set the stage here with why forensic social workers are important and even what we are, right? And the reason that this is so important to, I think, indigent defense in specific is because having social workers implanted in public defender offices transforms public defenders into partners of reducing recidivism, while at the same time not compromising the constitutional constraints of an effective defense. I'll talk more about this as we go. But I mean, personally, I think it's truly the only way to manage to do both, to enhance public safety while creating and keeping protections around people's protected medical information and the constitutional rigor of the defense process. I am working on coining a phrase called informed resolution, and particularly where essentially the point of social workers in public defender offices is to bring enough awareness on a pre-trial or pre-sentencing basis so that that can inform the court more effectively on what to do. And I know we've got some structures in place for that, but again, I'll get to that a little bit more. The other main reason that it's important to have social workers in public defender offices is because of behavioral complexity, right? Indigent defense receives the most clinically complex and the highest barrier individuals. So what I mean by that are people with multiple different diagnoses going on, intellectual disability and schizoaffective disorder and or opioid disorder, right? You could throw on there trauma and a history of human trafficking. These things compound and it impacts people to such a degree that they also end up being paradoxically, arguably the lowest executive functioning group of folks encountering the legal system. Right. So what I'm saying here is that the need is greatest because those who are most detrimentally impacted by medical, psychiatric, and addiction diagnostics are also far and away disproportionately, of course, represented by public defenders. And public defenders are great. I know lots of them, right? But that was hilarious. Swear about that. But the point is that we can't all do all the things. And a good public defender is a good attorney. They're not behavioral health experts. They can't and shouldn't really be expected to be able to very quickly sit down with a client and see, oh, this is not psychotic disorder speaking, this is meth-induced psychosis, right? And of course, some attorneys pick some of this stuff up after years of practice. But at the end of the day, if you start with a false basis, and then resolve a case, whether it's through treatment or AP&P or whatever, if the basis of that is off, then the fix is off, right? That's sort of what I mean here about ontology versus etiology. Jim keeps telling me that I need to like speak simply and I can't contain this level of nerd. So apologies, but I mean, I just have to highlight that there's, of course, a difference between clients who will legally fit a definition or a legal constraint for a certain type of plea. But the question is etiologically, so from a medical causal disease model perspective, is that really what's going on, right? So I'll talk more about guilty with a mental condition a little bit later and sort of the prevalence of folks that I have seen and continue to see that end up entering into that plea, even though they don't have a mental condition that will be effectively supported through that resolution, right? But the point here is that you bring some behavioral expertise and the ability to investigate a client from a privileged place. I want to underscore this is key to getting to the bottom of why somebody is engaging in the criminal behavior that they are. So I was in private practice for about 7 years. I was a crisis worker at University Hospital for a while. I really want to highlight here, privileged investigation is key to knowing what's up, because otherwise a client shows up in your office, whether you're working for Weber Human Services or McCady in the crisis office. All you really have are your agency's own records that you may or may not have access to based off of HIPAA, and then the self-report of the client. With social workers and public defender offices, however, we have way more than that. We've got the self-report of the client. We have access to discovery. We have access and the ability to collect all the records needed to see what's really going on with the client, going back to school and childhood, right? So that is a very unique position that I have not been able to see duplicated in any other field of social work or behavioral health. You can lie to your psychologist or your psychiatrist, and clients can lie to us. They do it all the time. But we have a broad enough picture that we're able to circle back to the client and say, hey, my friend, let's talk about these other things, right? And that leads again to this informed resolution, this ability to make sure that the defense attorney and ultimately the court has a better idea of who they're working with. The reason that's important is because at the end of the day, I argue that social workers and public defender offices are about fiscal responsibility. When I say we are surgical force multipliers to all existing public services, that's exactly what I mean. With our ability to collect information and more accurately diagnose and connect people to services, we can cut through the tape and be beneficial to local mental health authorities. We can utilize voc rehab, Department of Workforce Services, local homeless services, substance use disorder treatment providers and hospital systems. We can use those to greater effect because we have a greater ability to see what's going on. And I really want to emphasize that we've also been able to be a great support to enforcement. I pretty regularly engage in presentations to the Weber County Sheriff's Office up here in regards to managing inmates in the county correctional facility with severe mental illness or developmental disorders, right? And of course, this is free of charge because I'm just part of the defender office. So my point is that, again, this expertise happens within defense, but emanates out to be beneficial to all parts of the county. And then the last sort of argument here that I have is data and innovation, right? Forensic social workers and defender offices have a very singular ability to collect and utilize data on justice-related outcomes and develop innovative solutions at a local level. I'll have a slide about that in the Weber model in a little bit, but my point, and I know that saying the phrase JRI is like sticky in 2025 in Utah, right? Some people wish it never went away, and some people are like bon voyage. I remember JRI getting rolling when I was completing my master's degree. My practicum entailed doing a lot of county subsidized substance use disorder treatment for those who were exiting justice involvement, right? And I remember encountering firsthand the sort of struggles of getting something like JRI working. JRI didn't fail because the research is bad. JRI failed because we didn't have the infrastructure in place to make it work, right? And whether or not we want to keep using terms like JRI or just move on, my point is that forensic social workers are truly a bridge. We are tangible, actionable infrastructure within, especially in Utah, since indigent defense is pushed down to the county level, we are infrastructure within the county to support the county's best interests, including and especially public safety, right? So what is a forensic social worker? For starters, ideally, it's a master's level clinician. There's an asterisk there because as department scales up, there's room for bachelor's level social workers and case managers. LDA has a nice mix of some bachelor's level folks that can offer services at a better, more affordable sort of price point for wages, right? But a master's level clinician is needed, and is needed to be a core part of the defense team, because you need us to be able to utilize differential diagnostics within the DSM. And like, you take a master level social worker fresh out of grad school, not everybody is going to be able to parse out the difference between rigidity from autism spectrum disorder versus antisocial behavior. Those are completely different things. Sometimes they can look similarly depending on the social interaction, right? So to be effective here, though, we need folks who not only have a master's degree, but are really able to become great experts in the DSM and in clinical case management. So the role of these master's level clinicians is not about treatment. We don't do therapy per se with clients, but we engage in what's called clinical case management, wherein we have enough familiarity with the client and their clinical needs that we're able to, instead of just sort of like Legos plopping things together, we're able to identify the services that that hit the cause of the behavior that's leading to criminal action, right? You also need master's level clinicians because they need to be able within defender offices to perform ASAM assessments. So that's the American Society of Addiction Medicine, to determine a level of care for treatment. We also utilize risk need responsivity tools and sort of random other tools if we're trying to parse out what's going on with the client, like the MOCA, the Montreal Cognitive Assessment. If somebody had a brain injury when they were in junior high or just after high school, and that's well documented, but the question is, how is that impacting the person's behavior right now that they are violating protective orders, right? We need master's level clinicians to help get in there and figure out, is this something new? Is it a new psychotic break? Or did the client just start using drugs? Or is there some stressor in life, right? But beyond that, a heavy amount of psycholegal training is needed. Fresh out of grad school, social workers, master's level psychologists, right? Nobody really knows most of how the criminal justice system operates on an intricate level. And we need to know that. To be an effective defense-based social worker, you need to have a social worker who's able to understand competency and versus mens rea at time of offense, right? Needs to be able to understand due process and the rules of criminal procedure, mitigation statute and case law, critically ABA guidelines, because there's often a disconnect between maybe what is normal best practice in the community for like a therapist social worker versus us here with our scope and focus being supporting the defense and connecting that person to the right services that will reduce risk of future crime, right? So, and then lastly, to highlight the scope and role is that our work product is for defense, but it's to defense, but it's really for the community, right? So we operate under privilege, we write reports, we make referrals, everything gets shoveled to the defense attorney that then presents it to prosecution to either stipulate or to make arguments in court. It's meant to be shared so that everyone in that courtroom has a better idea of what's really going on with the client. Is this a scary dude that maybe prison is the right answer for? Because prison is for people that we're afraid of, right? And good reason. Or is this somebody where there's a misunderstanding and we're mad at them, right? But at the end of the day, prison is not the right answer because this is a human who still can function effectively and pay their taxes and raise their family. And by sending them to prison, it's a triple incurred cost that we don't need to pay, right?
Daniel, I have a quick question.
Yeah.
When you say you operate under privilege, does that mean the attorney-client privilege? Okay.
Yep,
That's what
absolutely.
I was starting to think that was probably it. Thanks.
Yeah. Thank you, Commissioner. And the thing is, oftentimes our defense attorneys will come to us with the work product. We'll connect somebody to treatment at a say Odyssey House Residential, and the attorney comes back and says, well, the client's husband has a letter to this program that nobody's ever heard of, and he can give her a ride there tomorrow, right? Instead of having the client be in jail for another couple of weeks while waiting for a bed to open up at Odyssey House. And that's the point at which we push back on our own team, right? We push back on our defense attorney to say, hey, look, I hear you. The problem is that this program that you're talking about, well, this will get the client out of jail quicker. This is an unlicensed program that doesn't meet residential requirements and is not administering strictly evidence-based treatment. So yeah, it gets your client out of jail quicker and it looks treatmenty, but the community will be better served if you roll with the other option of waiting for a bed at Odyssey House, right? And it's up to the defense attorney to choose. We don't run the case. We fully acknowledge the attorneys running the case, but we want to arm them with the best information, not only about the client, but what it is that's going to ideally reduce recidivism, right? So we operate within defense counsel, but our commitment is to the etiology, validity, and reliability of what's really going on with the defendant and how to serve the community. So, you know, fun fact, social workers have been in defender offices for a while. LDA's had them since the 90s. Utah County Public Defenders started theirs in 2021. And then Weber County, I came up here in 2023. And as Jim mentioned, I'm paid for by opioid settlement funding. And one of my social workers is through an IDC grant, and she's incredibly helpful and effective, right? But the problem that I hope became apparent as I'm talking about what is a forensic social worker and why we're here is that we're hitting some pretty real constraints on the availability of professional capital, right? You take any attorney fresh out of law school, you can cram them in a public defender office, and they can essentially get it and become really stellar public defenders, right? That's less the case with social workers, right? And if every single county is left of its own accord to find a social worker that even has any level of connection or understanding of the psycholegal nature of this work, I mean, that maybe is plausible in a few counties, but most of rural Utah, as we know, is quite rural. And at the end of the day, regionalization makes sense, right? CPS and DCFS operate on a regional perspective. It creates a training and command structure, and it creates clarity. So we thought, why not? We'll give it a shot. We'll ask the state of Utah for money to try and regionalize this. And with the right agreements in place, it's fully possible. And it worked. So the state of Utah gave us $850,000 to run a 2-year pilot project. And I'm bold enough to throw out this amount because I want to highlight that truly almost every cent of that is going strictly to labor. It goes to the 3 social workers that I was able to hire, master's level social workers, and the legal assistant over the course of 2 years. And we're collecting data that they're requesting to move forward. So in total, we're operating with me, a PsyD mitigation specialist, 3 social workers, a bachelor's level parental defense social worker, which we've been able to integrate our 2 programs to support each other quite a bit. I'm excited to tell you a little of that in a minute, and a legal assistant. So I just sent in the 3rd quarterly report because we started July 1. But of course, it takes time to hire people and get them trained. So we weren't really fully up and running until about September, October of last year. But here we are, just wrapped up the 3rd quarter. We've had 301 case referrals so far, and half of those occurred just this last quarter, which makes me happy because people are getting more effective. And key to this is not just training social workers, but also helping defense attorneys understand how to utilize us and to be able to spot as early as possible in a case like this client. I don't really know what's going on, but I think a social worker would be helpful here. Whereas, you know, the longer, and I'm sure Rich can attest to this, right, at LDA, the longer an attorney works with defense-based social workers, the more sort of surgical and thoughtful those referrals are, and the quicker they come. But when it's brand new attorneys are sort of like, there's a lot of missed opportunities, a lot of missed cases. So I'm glad to see that our volumes are increasing. So concretely, service lines and work product. This is what it is that we offer and what it is that we do to defense counsel, right? So I'm going to talk about a coordinated treatment release, and then competency and mental state offense consultations and mitigation investigations. Truly, the old ways here of connecting people to treatment through court order is throwing court orders treatment spaghetti at a wall. Matt, if you'll indulge me here for a minute, and I need one more volunteer, Commissioner Kamalu, maybe you'll roll with this as well, right? So Commissioner, you're the judge, Matt, you're my client, and I'm pretending to be an attorney, right? And we'll say Matt is assigned to me, and he's got 3 possession charges, and also we'll throw an assault in there just cause, why not? We'll keep it spicy. Matt's a pretty hot-headed guy. I think we all know that Matt Barraza's like, just kidding. You're the calmest guy I've ever known in my life. Anyway, so I go and I see Matt, my client, and I'm like, Matt, fortunately you don't have much of a criminal record. So I think I can get you out, but you're gonna have to go to treatment in order to sort of resolve this quicker. And Matt, your response is what?
Am I in jail? Is that
Yes, you're in
part
jail.
of this?
Yeah.
I'll do whatever you need me to do. Sure,
Yeah.
would love to. Yep.
Great. And then, well, then I tell you, okay, Matt, well, I need you to call around, and just find treatment, and then I'll connect with you at our next hearing. If you're able to get an acceptance letter somehow, then great, we'll present that to Judge Kamalu and we'll move forward, right? So then Matt goes back to the pod that he's being housed at, and then Rich, hopefully you're around in the pod, or I should have asked for another volunteer, but Rich at that point leans into Matt and it's like, hey, I know that everybody keeps telling you that First Step House is really great substance abuse treatment, but you should try Treatment R Us, because it's so easy, it's quick, they're nice, they're going to take care of you, and you'll be out of here in no time, right? And so then Matt, your response is Treatment R Us, yeah?
Yes. No.
Oh, totally. And then so we go before Judge Kamalu and we say, Judge, Mr. Barraza has been accepted into Treatment R Us, and we would, and then the prosecutor, I don't know, Michael Zimmerman, your name is in front of me here. So Michael's the prosecutor, and Commissioner Kamalu, what do you think? Would you be willing to maybe stipulate to this? You and Matt and Michael Zimmerman get together. Michael, what's your opinion? Are you cool with this? I mean, Matt wants treatment. Yeah. All right. Well then, so Commissioner Kamalu, what do you think? You pass the sentence. Sound good?
Probably a lot of judges would say, okay, go for it, everybody. But I know some difference between those 2 different groups that you talked about.
Right.
I understand where you're heading.
Yeah. And so then somebody goes to Treatment R Us, and maybe it's a good fit. Maybe it's not. Maybe it sticks. Maybe it doesn't. Research shows that court-ordered treatment tends to be about as effective as not court-ordered treatment, but that's still pretty low. It's about 40%. And I think that also fails to take into account recidivism rates and complexity, right? So what we're offering is the better way, rigorous clinical evaluation on a pre-adjudication basis. And this really is the point, because we want me, the defense attorney, to be armed with an evidence-based option to approach Michael and Judge Kamalu with something that's going to stick, right? So when I have my social workers initially receive a referral from a defense attorney, the process that we give the lingo we give the process is not just evaluate the client, but investigate and evaluate. And so they meet face-to-face with the client for 30 to 90 minutes, as long as it takes, to do an in-depth diagnosis, substance use disorder diagnostics, dual diagnosis, or a SPIMI primary, right? Do I use meth and I have pretty intractable depression? Or have I been schizophrenic for years and I use whatever somebody hands me as I'm on the streets and I'm unsheltered? And so we need to make sure that the treatment program goes to the right place, right?
Can you define SPIMI for us?
Oh, yes, thanks. So severe and persistent mental illness, right? So this is not just somebody with a DSM diagnosis, right, per the American Psychiatric Association. This is with somebody with a disorder or a diagnosis that is generally a psychotic disorder, but is so severe that it really reduces my ability to engage in daily life, to shower, to hold down a job, to pay my bills, to have meaningful relationships, right? And it can come and go. The episodes of the mental illness can come and go, but it's so severe and it's been around for so long that my level of executive functioning, my ability to make choices to take care of myself, continuously diminishes, right?
And one other thing here that I learned, I'm on the board for Davis Behavioral Health, and I have been my whole time as a county commissioner. That dual diagnosis is common. As I understand, 80% of folks who have substance use disorder have a mental health challenge. So, yeah, right. And so that's just so complex and challenging for folks.
You're spot on. And what's really killer here is that, so per the American Society of Addiction Medicine, any residential drug treatment program should be able to handle somebody with a dual diagnosis as long as their mental health disorder is stabilized. So I should be able, if I have bipolar 1, for example, which does often become a SPIMI disorder, and I also just really struggle with alcohol, as long as I'm not in an active manic episode, I should be able to go to almost any treatment facility and receive good care and work on my addiction and attain a level of sobriety and follow through with probation. SPIMI disorders and psychotic, like major SPIMI primary programs, are an incredibly short supply. There's truly 4 of them in the state of Utah. All of them are in Salt Lake County. And the reason for that is because it requires a bit of an economy of scale to be able to have the right training and social workers and physical location and interconnected services to operate a SPIMI primary program where also on a residential level, where also somebody's going to stay. If I go to residential for addiction purely, it's probably going to be about 3 to maybe 4 or 5 months. And then I step down from residential to another level of care. If my primary issue is lifelong schizoaffective disorder and drug use on the side, again, that executive function has reduced and I need a lot more case management. I need a lot more support. The point that I'm getting at is that if we have folks who really have, say, meth-induced psychosis going on, but they think it's a benefit to say, no, judge, I have a mental disorder. And then the defense attorney's like, no, judge, my client has a mental disorder. And then that person gets sentenced to a true SPIMI primary program. We are creating instantly an intractable backlog of very valuable minimal resources. And meanwhile, defense-based forensic social workers can cut through that and help both the defense attorney as well as prosecution and the judge understand that, look, we don't have to throw the book at this guy harder because he doesn't have a major mental illness. But in fact, this is good news because treatment is going to be easier to administer and they're highly motivated, right? Again, it's about the right person in the right place. So level of care speaks to that as well, residential versus partial hospitalization. That's like day treatment or IOP. A lot of times prosecutors want clients because they feel better, right? If you go from a jail to another seemingly secure facility, right? Residential is actually not locked. It's nothing like a jail. People can walk out the door, but there's social blowback from that. You're not supposed to. It's a closed campus, but it's not the same as being in a jail or a locked psych unit. My point here is that sometimes what is clinically medically indicated for someone is, say, PHP IOP. And then helping to furnish to the defense attorney the information that will help prosecution and the judge realize, okay, on this client, we can try it out. We've also got housing lined up and transportation and a job. Yep, let's order him to IOP. And here is the specific IOP program, right? But we dig into the criminogenic history as well. It is very essential that we make it so that our attorneys send us the UBI or the III, so we can look at the criminal history, look at the discovered collateral. And then this is the biggest sort of benefit. Within the risk need responsivity model of criminogenic risk, right? Responsivity is the part that comes at the very end that says, okay, there are a few barriers here that if we don't properly address them, it's going to diminish the treatment efficacy of the criminogenic need stuff, right? So we can order someone to substance abuse treatment, but if that person is also, say, a female with a major sexual abuse history and possibly like maybe she was trafficked, right? Not all treatment facilities are going to be able to approach the client with that level of trauma-informed care, right? It would be nice, but at the end of the day, they're not that prevalent, right? We're able to go in there and identify those key responsivity factors that will help someone be more likely to succeed at treatment, and then by extension, reduce their future recidivism, right? One thing I'll say here before moving on about criminogenic risk need, though, is that a lot of this tends to fall just by default onto the local mental health authority, Davis Behavioral Health, Weber Human Services, et cetera, right? Wasatch Behavioral. And those are entities that have the care or the responsibility of providing care and support to everybody on Medicaid in that area, of which a criminal justice involved population is a diminishing amount. And in order to be effective, treatment for criminogenic need needs to address at least 4 factors, of which drug use is one of them, right? There are a lot of programs that do great at treating drug use, but we also need programs that can challenge antisocial thinking, that can teach pro-social interpersonal skills, that can address entitlement, and that's sort of connected to the antisocial thinking, right? And so to this end, we also will try and tailor our treatment recommendations that go to the defense attorney to focus on, if somebody is higher criminogenic risk and need, we want them to go to, say, First Step House or somewhere who's developed a program that is really set to hammer on that and hold clients accountable, right? It's not Treatment RS, for the record. Treatment RS is terrible at criminogenic risk. Anyway, the last thing here is there's a bunch of barriers that exist that I think the behavioral treatment system and then the court system don't know why or how they don't connect very well, but it's because of these barriers, because of Medicaid needs. TAM is the greatest thing that's ever happened to justice-involved care. I'm just telling you that right now. Transportation, multi-jurisdictional cases. This is another big thing. If I am an attorney here in Weber and then the client has cases in Washington County, maybe I'll reach out to that attorney, maybe not. But if the client's being lined up for treatment, part of what we do as forensic social workers is help those attorneys to connect and create more global resolutions that will support the treatment and support the service connection, right? So since the pilot began, we've had 110 defendants connected to treatment from 168 referrals. So the balance of those other 50 is a mix of folks who went to prison and a mix of folks who we honestly had so many barriers that the treatment connection fell through, but we have their information and we can try and use that for next time. So competency and mental stated offense consults, right? Key here is that, again, attorneys are great, but they're not behavioral health experts. Any given attorney can come and say, I'm having a really hard time working with a client. They're not making sense, or they're angry, or they never listen to me. And so they file competency because they're a difficult client that has behavior that's out of the norm, right? But the key here is it's not just that you're difficult and can't do items A through G in the statute, right? Work with counsel, understand the adversarial nature of the system, maximum and minimum punishments, et cetera. It's also, is there a qualifying mental condition? Is there a psychiatric disorder and or intellectual disability? And restoration for those two things is very, very different. So we go in, if we receive the referral, and we'll evaluate the client, and we'll come back and let the attorney know, like, what the diagnosis is, if there is one, and opine on a few things. So one outcome is that we come back and say, yep, you're right. This client is not competent. I recommend that you file immediately. Nationally, there's been a 70-30 split. You take 100 cases, file competency, 70 come back as competent, 30% come back not competent. As I'm sure Rich can attest and remembers from 2020, 2019, that number had actually flipped in Salt Lake County, wherein 70% of the filings from LDA attorneys were coming back not competent. And the reason was because of forensic social work involvement. We're screening out the people that competency should not be filed on, right? So of course, somebody can have a diagnosis. They could be bipolar, but also be competent, right? Or there's good old-fashioned drug-induced states. If maybe they're not competent at the moment because they're withdrawing from a 2-month-long meth bender, and they're going to be paranoid and guarded. And if they get some sleep and we circle back in a couple of weeks, they're going to be competent. But if we file competency, that's probably at least 45 days of just time that we're burning, right? Or there's just clients who are difficult and competent, right? If we come back and we advise the attorney that the client's not competent, we also draft the petition, which includes our observations, and a court order that helps identify whether or not somebody needs to be evaluated by a DHHS person who specializes in psychotic disorders and mental illness, or developmental cognitive disabilities. Because again, these are wildly different fields. And if I'm used to working with psychotic patients and I'm dealing with a competency evaluation of somebody that's low IQ, so they're not psychotic, but they're very concrete, and there's a lot of acquiescence bias going on, I'm absolutely going to be like, this person's great. They're totally competent. When at the end of the day, they don't actually really understand their charges, and they're not able to help aid in their own defense, right? In the event, though, that we come back and tell the attorney, look, I really think that they are competent, we also provide accommodative support towards resolution, because it doesn't help anybody for the client to sit in jail for another 30 to 45 days while the case is on hold so that we can be told they are competent. So instead, we'll go out with the attorney and try and translate a little bit, try and help the client to move them along. And the idea is resolution. In all cases, we try to go back to a coordinated treatment release, because if we can line up resources in the community that are going to properly support that individual to reduce their criminal risk, then everybody wins, right? So we also gather records and we opine on the mental state at offense. It's sort of mind-blowing to me how often prosecution and defense will refer to somebody's mental state at the time of offense as, were they competent at that time? And that's a different horse and a different barn, right? But the mental state at offense is absolutely germane to how the attorney wants to proceed in defending the client. So since the pilot began, we've saved about 750 court or jail days from 66 referrals. This is an incredibly conservative estimate for a couple of reasons. Number one, this is just purely going off of the fact that upon being ordered to evaluate competency, the DHHS evaluator has 30 days from the day that they're ordered to execute it. And then of course they can file for a 15-day extension, right? I haven't run the numbers here, but I have a colleague who ran the numbers of all the competency cases submitted, filings submitted from their office over the course of several years. And literally not one of them didn't end up having a 15-day filing extension. So this 750 days is me operating off of a 30-day court and jail day savings, when realistically it's probably 45 per case. And then in addition to that is that we get to move forward to a plea resolution that is going to serve the community, right? I'll also note that every filing that has occurred against forensic social work advice, so when one of my social workers comes back and says, look, this person does have an intellectual disability, but they are competent and I can work with you to get the case resolved. And the attorney said, nah, I'm going to file anyway. Every single time that's happened, the client has come back competent, right? And then we are also having an increasing rate of evaluator engagement. So the other part to this is that a DHHS examiner, great friends and colleagues, right? They're psychologists, they're doctorate level folks. They're also operating off of a 30-minute to 1 hour, maybe sometimes 90-minute interaction in a vacuum with the defendant. And I can't stress enough how especially the more like delusional disorder or the more sort of complex that a client is, the more frankly impossible it is to opine on someone's competency in 45 minutes to an hour. There are a tremendous amount of evaluations that come back and get it wrong. And so then we've got to go into the fight of seeking a second evaluation, or does the defense attorney hire a private evaluator, right? And so that's, again, more drag, more just, I don't want to say wasted time, because doing the right thing is never a waste of time. But all the same, if we can just skip to the part where we share records and we share information with the evaluator so they can get all of that right at the beginning, we can increase case resolution efficiency, right? So lastly, mitigation investigations are primarily focused on major felony and complex cases, right? This is about culpability, mental conditions, and affirmative defenses. So in these cases, one of my social workers will, for a long haul, meet with the client several times, gather every record, consult with the attorney. And we're looking at, is there a involuntary intox defense here, or an involuntary intox? Or is the client's mental stated offense a result of intoxication withdrawal, or is this a drug-induced psychotic episode? So mental illness and diagnostic validity. Again, there's a huge difference between defendants who can check a box because they meet some statutory things, or because defense and prosecution stipulate. This happens often with the guilty with a mental condition plea, which I think is a step in the right direction in terms of better serving clients with mental illness that are criminal justice involved. But the difficulty is if defense and prosecution simply stipulate and the mental illness in question or at play is not actually what was driving the boat at the time of offense, right? Like I can have PTSD, and I can have moments in my PTSD where I'm very reactive and overwhelmed, and that maybe I do fly off the handle and throw a chair out a window, right? That happens. But the question is, was my PTSD actually meaningfully relevant to the offense being adjudicated? And outside of social workers and public defender offices, I argue that there's not really a meaningful way to wrap everyone's head around this. And again, the reason this is important is because if we create a resolution that involves me getting treatment for my PTSD, but what was actually going on is I was responding violently to coercive control and domestic violence from a partner who was abusing me, right? Then suddenly we've sort of set up, I think, a false hope, right? Where a client tries to do the things to get the resolution, but then again, if that dynamic in my partner is abusive, and then I lose my shit again at my partner, and then here we go, the cops are back, and suddenly the whole plea, the whole GMC plea is maybe at risk because it was sort of the wrong focus of the resolution in the first place, right? Developmental disorders and intellectual disabilities versus psychiatric illness. This completely changes, like the services and supports for developmental and intellectual disability goes to the route of DSPD and other community supports. If we take somebody who struggles with addiction and also has a low average or below average IQ, we end up again putting them in the wrong place, in the wrong treatment, and we sort of set them up to fail because they can't engage in the treatment the way that the average bear can. So it goes back to those responsivity factors, right? And then, we help out in retaining and coordinating experts. Sometimes knowing whether or not a toxicologist versus a psychiatrist needs to be hired, or a psychiatrist versus a psychologist, et cetera. And this is something that I'm very excited about, and goes back to my point that I argue that forensic social workers, while we work through defense counsel, we benefit the community. Increasingly, we're able to, with the attorney's permission, pass on our mitigation investigations and our clinical understanding of a client to the Department of Corrections, so that as they onboard into the prison, then prison mental health, behavioral health has an immediate leg up on this client's history and can better serve them and their needs. But also it helps them get a forward jump on rehabilitation issues. That's especially true with sex offense clients, and being able to help sort of cut through some of the processes and make it so that the Department of Corrections and our colleagues there have extra information that will benefit them.
Hey,
So-
this is good. Hey, if I could interrupt real quick.
Yeah, please.
We talk about getting all these mental health experts and other professionals. Who pays for them? Does this go to the person we're trying to help? Does this go on his beer tab at
This-
the end of the day? And he's gonna recover it? I mean, these guys don't have no money anyhow with
Exactly. So this is a great question, because sometimes, and I'm sure Matt could speak more to this, right? If there was cause in the defense of a case that an expert needed to be hired, but the attorney opted not to, well, then you've really opened up the case for ineffective assistance of counsel appeals, right? So who pays for it? Ultimately are counties, because the state wants counties to pay for indigent defense. And to some degree, the IDC largely funds through grants and supporting proper, right, rigorous defense. My point is, if we can cut through and either not retain experts that are unnecessary, and then provide the support as to why an expert wasn't needed, we have just covered the attorney for ineffective assistance of counsel, and we've also helped get the case resolved more effectively. Matt, I'm going to let you speak to this more.
Yes, I'd love to jump in. So Commissioner Thomas, most counties have a designated line item for defense resources. It's called defense resources. It would cover expert witnesses, expert consultations, investigators needed to investigate a case. And the amount in those accounts varies from county to county. Some have more designated, some have less. What we have found is that, at least when I came on, that there really wasn't a whole lot of use of those funds, and those experts weren't being requested, especially in some of the smaller counties throughout the state. And so since then, we did establish a fund within the IDC where in the more rural counties, the smaller counties, if they spend through the local account there for experts and such, they can apply for additional funding through the IDC for that. So that's maybe more specifics than you needed, but that's how those resources can be paid for.
And it's such a great question, Kendall. I'm so glad you asked that. There's something that is in place so that Davis County is connected to Weber a little bit for this, right? So I guess that's a little bit toward regionalization. I can't remember exactly how that works, but anyway.
Yeah. Spot on. And so we are at present supporting, those Davis County defenders and trying to provide some guidance and help in terms of when a mitigation investigation is needed. So, I mean, case in point, so this box here that dropped down, estimated $800,000 in savings to courts and the county systems. That's come from 9 first-degree felony cases that our mitigation specialist was able to help resolve without going to trial. And these are clients who really wanted to go to trial, right? And it's not that we ignored them and overrode them, right? It is that having a social worker with the defense team was able to process through discovery with the defendant to help them understand, like, okay, wait a minute, now I understand what, like, you know, a lot of times clients just feel like, well, my attorney's just not fighting hard enough for me. And a lot of what's required in those cases is to sit down with the client to go through discovery and to help them sort of just work through the if-thens. And all 9 of these cases ended up resolving outside of trial costs. So the costs of which a county pays for the prosecutor, right? And it's usually on a first-degree felony. There's a couple of prosecutors that block out a week-and-a-half long trial, as well as then the costs of the defense attorney. And there's usually going to be a first and a second chair defense attorney. So those costs, again, come from a mix of the IDC and county funding their indigent defense processes, right? And then there's the costs affiliated with the court system itself and the costs affiliated with the sheriff's office and the bailiffs to run security and bring the client back and forth. The court process is expensive and it's the right thing to do. Due process is American, right? And at the same time, if we can work with the client to bring them along, and if we can then use the mitigation investigation information to help prosecution, to help the court understand where this client was coming from. Again, were we dealing with somebody who is fundamentally a sociopath and is trying to burn down buildings just to burn down buildings? Or are we dealing with somebody who, in the throes of a schizoaffective episode, believed they were being pursued and they were cold and they lit a fire in a barrel in a stairwell to stay warm, and then that put the building at risk? These are 2 different things. And in one case, if you manage the mental illness, you manage the risk of criminal behavior. And in the other case, you can't really manage sociopathy, right? There's no treatment for that. Well, I can't say none, but there's not a lot of evidence-based treatment for that. So one thing I want to note here is this is an exciting opportunity. I've got a good friend and colleague, Dr. Emily Salisbury at the U, and I was chatting with her about wanting to run a cost analysis on things like this, the savings and the county level cost savings, the state level cost savings to, you know, resolving a case outside of trial that doesn't need to have gone. And so hopefully I'll be chatting with an economist at the U here pretty soon and sort of running some numbers. But that's more the kind of stuff with the data that I've been collecting from this pilot program that I think will be able to sort of retrospectively show the value. So I'm going to burn through this really quick because I want to highlight the actual complexity of the process here and why that old way of throwing treatment spaghetti at the wall is sort of less effective. And please also recall that no matter what an attorney refers to us, we always try and end this in a coordinated treatment release of sorts to connecting the client to the services they need. So even if a client is found not competent, they go to the state hospital for restoration, they get restored and come back into the system, well, their case still has to be resolved. And oftentimes that's still resolved with probation. And the question is, are they going to be successful on probation, or is their mental condition outside of a hospital without that kind of structure going to decompensate, and then they're going to fail probation, end up with an OSC back in the system, right? So if we can get the wraparound services and connect with probation effectively, there's a greater chance that the client succeeds, right? So it starts here. We get a referral either from the public defender or a community partner. Our legal assistant reviews the referral for eligibility. If it comes from the defense attorney, they're eligible, right? But if it's a community partner, she checks into whether or not it's a public defender client and what status of the case it's at. And then it's assigned to an forensic social worker, where again, right off the bat here, the investigate and evaluate, digging into not just 1 hour convo with the client defendant, but also the criminal history, gathering records, and talking to collateral witnesses. You learn a lot from talking to someone's mom. I think we all know this. And as a therapist in the community, I'm not allowed to do that. As a defense-based forensic social worker, I'm absolutely allowed to call your mom and see if Commissioner Kamalu's version of events is really what happened as she grew up, right? In the event that the client is more complicated than a straightforward treatment release, well, then a consult happens between the social worker and the defense attorney, and they figure out, well, what do we do? What can we do? What's going to serve the community? What's going to help resolve the case constitutionally, right? When a treatment partner or treatment option is identified, Odyssey House, DSPD, supportive services, crisis supports, right? Then they make the referral to that treatment partner. They review the clinically driven information. So again, this isn't just a questionnaire. This is from a master's level clinician. And they decide whether or not to accept the client or not. If they deny acceptance to a wait list, so this is key. The client's in a jail right now. This is pre-adjudication. And if the treatment partner says, no, I don't think this client's right for us, it's just not going to be a good fit. Okay, well, then the social worker keeps looking until they find the right place. When the right treatment partner is found, they send us an acceptance letter that is not an acceptance to a specific treatment date acceptance or a promise of treatment necessarily. It is the client is on our wait list. We've reviewed the clinical information. We know what we're getting into. We know that we're going to need to be ready to manage this person's bipolar disorder in addition to their polysubstance abuse, right? Well, so they send that waitlist acceptance letter to the legal assistant and the forensic social worker. They update some tracking information. The social worker forwards the acceptance letter to the attorney along with specific release language. Because honestly, a lot of community partners, residential treatment facilities don't like working with court-ordered folks because, again, the clunky system where it's like if a judge says, yep, you'll be released on the 10th of May to Odyssey House, if Odyssey House doesn't happen to have a bed available at that time, well, we've just put the client at risk of violating their probation agreements. And also, if a bed became available on the 7th, Odyssey House literally cannot afford, none of these community providers can afford to just hold an open bed for 3 to 5 days until that release date comes, right? So part of that acceptance letter is acknowledging a release window and a few other constraints such as transportation, right? This gets forwarded to the defense attorney to file with the court, to chat with the prosecutor, seek stipulation, etc. And the social worker just tracks. We just wait until the ruling. So if the court, whether it's a lack of stipulation or the judge doesn't like it or who knows, if it's denied, then the social worker does another psycholegal consult with the public defender and updates community partners. And then ultimately, depending on if, say, it was prison that was ordered or just jail to close with no treatment requirements, right? We consolidate the data that we've collected about that case and that client, and we close it up. If, however, treatment is ordered, the social worker identifies the release window, updates community partners, and it gets transferred over to the legal assistant that just tracks it. So if my release is July 31st, right, then there's really nothing to be done until July 31st, which is say the first day that I could be released. And so at that point, say July 31st comes, the legal assistant connects with the social worker. Everything here is documented and ready to go in our system so that we're not reinventing the wheel at this crisis moment, right? It's just like we want to get them out and rolling. Legal assistant notifies the treatment partner, hey, they're ready for release. Whenever you've got a bed available, let us know and we can help get them released properly, right? As soon as a bed is available, say it wasn't July 31st, but August 10th, and then Odyssey House calls our legal assistant and says, hey, we're ready to go. Legal assistant coordinates with the county jail to roll up for release, and then confirms eventually, hey, the client made it to Odyssey House, great. And then the case is closed and the data is consolidated, right? What I want to highlight here is that, again, with defense-based social workers being actual tangible infrastructure, right? Being a mechanism for this to happen, because it literally just doesn't work without us as a bridge. It also means that we have a sort of unprecedented ability to collect data longitudinally, case specifically, on a nitty-gritty level, right? And it's housed within defense counsel, so it's not at risk of being used against the defendant, and it's compliant with HIPAA and 42 CFR. We can destroy the records that we request in compliance with 42 CFR, but we still have our work product. We have the social worker's write-up, we have the acceptance letter, and then in the event that a client does come back 6 months later, 6 years later, 2 days later, because that's how addiction works sometimes, we're not starting from square one. We immediately have information for a great case plan, right? And I want to highlight that the data that we're collecting can also be made to be very county specific in identifying concrete resource needs and holes that may exist in certain areas, right? Also collecting program specific data, and we're able to see the connection rate. So of everybody court ordered to whoever sent the acceptance letter, did that program actually end up picking them up? There are a lot of programs that will say yes to a client and then just essentially the defendant gets ghosted until they're released max time serve. And then the whole thing falls off. Like if I'm released max time serve, I was going to go to treatment and now I'm just out. Again, we're looking at an increased risk of OSCs or relapse, right? Defendant-specific data, desistance measures as a form of identifying recidivism. When it comes to OSCs, honestly, my next pilot project that I would love to run is connecting with AP&P to say, hey, identify 100 clients that have failed probation, that you want to know why. Let me review the information and see if, had forensic social work been involved pre-adjudication, I'm willing to bet that we would have been able to avert that failure. And then just again, waste, fraud, and abuse, wasted treatment, the old like ontology versus etiology. I want to note that again, so having collected that data, there's an opportunity to develop treatment infrastructure, countywide, statewide, whatever. Here in Weber, we're really focusing on the sequential intercept model to create diversion reentry services and to better inform specialty courts. And again, here with the chronic and complex population, this really is the paradox I was getting at the beginning. Individuals with the most complex diagnostics and the lowest functioning ability end up becoming public defender clients as opposed to private counsel. They have the most need, and it becomes a vicious circle. And this is why incarceration rates of those with developmental disorders and psychiatric disorders in prisons is between 4 and 10 times higher than the general population. I think we can help fix that. I just wanted to throw out, yeah.
Just also, I had never heard of the sequential intercept model before becoming a Davis County Commissioner, and then especially with our Criminal Justice Coordinating Council and with the Davis Behavioral Health member of that council, Dr. Todd Suter.
Yeah.
I learned what that is, and it is a big deal. And we have some really great things going, and others that we hope to keep getting, or all of it to hope to keep getting better and better. But anyway, if that's a new term for folks, it's super interesting, that model.
It is, and it's helpful because another aspect that I didn't mention earlier, but when it comes to recidivism and when it comes to criminogenic risk, there is an iatrogenic effect wherein if we put somebody who's criminologically low risk in a treatment group with folks that are criminologically high risk, it tends to just elevate the risk of the low risk person.
Right.
Right.
You want to catch things early. My
Yeah,
language is
yeah.
want to catch things early and have the appropriate intervention.
One
That's
of the
a big
trick,
deal.
yeah. Well, and one of the tricky parts about a lot of this research is that, and especially when it comes to recidivism, is that there's studies that come from people exiting prison systems. And the bulk of cases end up going to of district court cases end up being jail and probation over and over again before they end up being prison cases. Pre-adjudication jail is where the most harm is done to iatrogenically from the criminal justice system, right? If I end up in jail for 10 days and I lose my job, and then my kiddo is impacted by that, and my partner is impacted by that, right? There's more harm from the pre-adjudication jail process criminologically than there is from prison. And so that I'm not making myself very clear here, but my point is that having us involved for those cases coming in and out of local county jails before adjudication, and wherein prison is not even on the table. If we interrupt the stability of someone's pro-social life, it increases antisocial odds, if that makes sense. I just wanted to highlight here that having social workers in defender offices is not just about serving the defense attorney. It ends up being a mechanism to help services grow in every other part of the county. So this is the Weber model that I've been working on developing with some colleagues here. We've got the defense-based social workers, Weber Human Services, the Weber Sheriff's Office Reentry Team, and Ogden Police Department Homeless Services Advocate Team. All four of us are dealing with individuals with complex diagnoses, with repeated attempts at whether it's drug treatment or trying to be stabilized long-term on medication. The problem is people end up going between systems. Once a client goes to jail, they fall through the cracks of the local mental health authority, or they fall through the cracks of other services. When someone is in jail, that's where we can shine and help to do this investigation and identify things like complex clinical needs. We can collect records and we can support corrections. And then sort of connect with Weber Human Services to make sure that the moment the client exits the facility, they are still up and ready to go and connected back into the right level of care of services. Without going too far into the mud on this, the point is that the four of these organizations, we've been able to work together to help identify and develop specific community partners and resources where previously things did not exist, right? So we're creating an oasis out of what was in some ways a desert for specific needs, right? We've also been able to increase our connection with the parental defense social worker here in Weber County, and there's about a dozen cases of mutual case support. Instances where the parental defender was trying to help the client in their case to get custody back of their kids, and we were able to help that client get into the best possible treatment program for long-term success, and then they were able to basically pivot that corner and get custody of their kiddo back, right? Conversely, we've had times where we've been able to utilize the parental defense social worker to help us understand where things are at with some of those major felony cases, right? If somebody is looking at aggravated homicide and also going through DCFS court, it has been really helpful to be able to coordinate the two teams. And there's still a partition in terms of it's not like we show up for each other's cases, but just the collaboration of information. Targeted prevention services. I've been working with Weber Human Services and communities that care as we work with defendants, and we're able to identify like, oh, you've got 3 kids at home. Oh, you're the primary breadwinner and your case is looking pretty grim. I bet you if we could refer your family specifically to some prevention and support services that could really help keep these kids out of crisis, right? So here we've been able to help meet broader community needs on a targeted basis, where otherwise these kiddos, would have been more of a creek. Weber State, I've taken on some master's level interns, students, and so that's been great and would not have happened without the pilot program money. And I did just find out, I've been sort of consulting with Weber State about the possibility of launching a Master of Criminal Justice, a dual program where somebody can exit with a Master of Social Work and a Master of Criminal Justice. And they are filing the paperwork to explore that formally, which will be huge. And then recovery residences, there's a partnership between a private entity called 3H Living, and then with the help of Weber Housing Authority, and then our efforts from Defense-Based Social Work, we've been able to, now 3H Living is looking actively for sites to purchase and turn into recovery residences or sober living, right? Because after somebody completes 3 months of residential addiction treatment, you're not magically fixed forever. There's a process, right? If I broke my leg in the 9th grade, it was a tib-fib fracture. It was hanging by the skin. It was crazy, right? I'm not fixed after surgery. It's not like after the plate and the 8 screws were put in my leg and I'm in a cast. I'm not just good to go, but I also couldn't stay in the hospital forever. So I needed to, go down to the level of care of the lazy boy chair in my living room for 3 months, right? We need more downstream level of care support in order to not end up with wasted treatment efforts, right? If it's 3 months of residential is doing great, and then I exit that to nothing, to no supports and homelessness, it's almost a guarantee I'm going to relapse, right? So having social workers here in Weber State, in Weber County, I've been able to try and help build community connections and individual private interests to support community safety and treatment success. So this is my last slide. It's just one of my favorite memes ever. And I feel in my heart of hearts, I am and have always been a fiscal conservative, right? But you have to spend money to make money in private capital, and in government and in criminal justice, you have to spend money to create public safety or to create the service, like to not end up spending more money down the road. So instead of a big pile of ladders, I argue that forensic social work can do more with one ladder, right? And impacts on reduced treatment waste, reduced order to show causes, reduced ineffective assistance of counsel appeals. There's a case here in Weber County that's coming back on its 3rd or 4th appeal. It's an ag homicide, right? That case has written a lot of case law has come out of that. But I'm sure that given a crystal ball, the funding for the original defense would rather have just avoided those appellate issues, right? Quicker complex case resolution, de-siloed social programming, yada, yada. So this is the question slide. I went way over my time. I'm so sorry. I hope this was helpful. I'm happy to answer any questions or at all.
Yeah, I didn't see any other questions on the chat, but perhaps if there's anyone who's held their question. I know I asked and Kendall asked along the way, but anyone else, or just even a thought?
Madam Chair, if I might for just a minute.
Yeah.
Thank you, Daniel. Good presentation. I think I would take issue with the notion that JRI was a failure, and I would instead characterize it as it's my belief that JRI has been abandoned by policymakers and legislators. I mean, I think that we made efforts, and I think we all knew going in that resources were an issue with that. So I would politely take issue with the idea that it was a failure, because I just don't think it was, because I think the data and the science behind JRI and the evidence-based practices are really what we ought to be doing. And that's perfectly symmetrical with why we have social workers in our offices, is really to address those sorts of criminogenic issues that come down. The other thing, and this is sort of hope that we can all be collectively on the same page. You know, it's sort of to Commissioner Thomas, one of his questions is really protection of Medicaid, both targeted adult Medicaid and regular Medicaid. You know, I'm sure most of us here know we have a trigger law in Utah that if Congress, or God forbid, some sort of executive order comes down tomorrow that says we're changing the match, we have an automatic trigger law where we won't have Medicaid available. And Medicaid's been a game changer for the kinds of treatment modalities that we can put people into. Without that, and without social workers to be able to figure out what's the right treatment modality. You know, you talked about ASAM, which is the level of treatment. That's a critical component in trying to decide where to put people. And again, that's where we get our bang for the buck with social workers, is the understanding and the identity of educating people about where's the right placement for people. Because you know, as you know, Daniel, we have a lot of judges that say, I want cats to close, or I want, you know, which is our in-jail treatment program in Salt Lake County, for those of you that don't know, or I want to have, you know, some sort of inpatient treatment, when really the ASAM evaluation and the help of a social worker can help us say, wait a minute, Judge, here's something better we can do with that person that's going to save everybody money along the way. And so those are some observations from my point of view, but excellent presentation. Thank you.
I appreciate that, Rich. And I just want to know real quick, I feel free to firmly disagree. I should note that my dark and terrible sense of humor, the JRI being a failure was tongue in cheek for me. But I'm with you. Protecting Medicaid and then having boots on the ground capable of making these connections, wildly different outcomes. Yeah.
You know, the National Association of Counties, one of their initiatives, and I'm sure it's all of our counties in Utah's desires, that Medicaid doesn't go away when someone who had it beforehand enters our jail. It would sure make a big difference if people receive that in the time that they are incarcerated. And especially, right, when it's pre-adjudication. Oh my goodness.
Yeah.
So anyway, yeah, thanks. Great comments, Rich. Anyone else? Well, thank you so much, Daniel. We appreciate you, you know, for what you do, and also just helping to educate all of us. It's
Thank you.
just
I
makes a
appreciate
lot
you.
of sense to me. It just seems really kind of common sense to me, honestly.
Yeah, well, and I'm a big fan. I had to like cut the presentation at some point, but I also just think it's important. Probably we're all on the same page, I'm sure here, but the difference in cost between building more prisons and shoveling people towards them is, I think it's important to acknowledge more than just the cost of a prison and running it, right? If somebody gets connected to treatment and instead of prison goes on probation, treatment, and then they go back in the community and they're seeing their kids and they're paying their taxes and they're contributing to their church group, right? Like all of that is an economic gain and support. Whereas once somebody enters a prison, it is only costs, arguably, right? So what I'm getting at is, I'm excited to chat with that economist and try and work out a model that will make it clear, factoring the multiple layers of social participation and how much more, I mean, values aligned, I think social work is in criminal defense, but also like the almighty dollar, I think will also prove that this is fiscally more responsible.
You know, receiving centers that started with Davis Behavioral Health doing one, and the state considering that a pilot, that was taken up by a University of Utah researcher to prove the fiscal benefit, et cetera, right? And similar thinking, similar upstream effort with receiving centers now going all through the state.
Yeah.
So, yeah. Hopefully you'll have somebody who will take this up and give you some more data. That'd be good.
Thanks, everyone.
Yeah, thank you. All right, well then, there's always a spot on the agenda for public comment, but I don't see anyone that I don't already know. So anyone have a comment as a member of the public? Okay. Also, I think probably Katrina caught it, but Paul Dodd was in for a lot of the time. Oh, and Josh, you're watching that too. Good. Okay, any other business, Matt, or that anyone has?
Next commission meeting. So historically, we merge our May and June commission meetings to go over the grant applications and have enough time for those to get back out to the counties. So was looking at the calendar and it looks like that would fall on June.
Maybe we want to do it at June 6th, just so that we can have the
I was looking at
decisions early in the month.
yeah, I was looking at June 5th is a Thursday, Katrina. June 5th at 2. So we will send some invites out on that, and if there's any major conflicts where we don't think we can get a quorum, we can look at alternatives. But if those who are here, if you could give us a thumbs up if that looks okay for you now.
I have an appointment, but I think I can move and adjust that. That's what I'll do.
Seeing lots of thumbs up, so I'm cautiously optimistic about that. Good. Okay, great.
Yeah, that is great. Okay, well, thank you so much, everyone. Thanks for taking time. Really great attendance today. Appreciate you. See you soon. Thanks, Matt and everybody.
Thanks, everyone.
Bye-bye.
Thank you.